Dr. Sonali Ghosh is a distinguished academic and researcher, currently serving as the principal of our institution, Swami Vivekananda Institute of Science and Technology. With a BSc Honours, B.Tech, M.Tech from Calcutta University and a PhD from IIT Kharagpur, she has over 22 years of teaching experience and 9 years of research expertise. Dr. Ghosh has published 13 papers and holds 5 patents. Her contributions extend to roles such as guest lecturer, examiner and session chair at international conferences. Recently, she was honored with a certificate of recognition for her valuable and exemplary contribution in the education sector by Ardor Media and LinkedIn at New Normal Leadership Summit and Awards 2023. Additionally, she successfully completed 5-day academic leadership workshop of Mission 10X by Wipro. Notably, she has received recognition from the WHO and the Indian government for her impactful work. Dr. Ghosh is a professional member of ACM and has completed various advanced courses including sustainability and intellectual property rights.
Good evening to my dear colleagues. I welcome you all to this 5-day FDP on intellectual property rights, fundamentals, application and importance in academia. It is in association with IQAC and IIC of Swami Vivekananda Institute of Science and Technology. And my topic will be on the very basics or the fundamentals of IPR. Now, before starting my topic, I would like to ask you, like 5 years ago, we are academicians, right? 5 years ago, there was not so much buzz about this IPR. Am I right? How many of you had a very good knowledge or a good knowledge about IPR 5 years ago? Just you can raise your hands. 5 years ago, did you have a knowledge? Now, right now, how many of you have a very good knowledge about IPR? You can just raise your hand. There is nothing to be ashamed because I fall into the next category, like very little or less knowledge about IPR, and I raise my hand because I have quite less knowledge about IPR and I am in the process of learning and giving a deep dive into what is IPR, because you cannot do without IPR right now. Like so much of patents going on in the academics, patent is one of the most mandatory things now, right? Am I right? Patent, we cannot do without patent, we cannot do without research activities and leading to patents right now. So we have to have some knowledge about IPR. Now, before coming straight into IPR, just starting what is IPR, let me make you understand or explain it in a very, very simple term. Like say if you own a house, a land, a car, motorcycle, vehicle, or say a land, farmland, or an agricultural land, or maybe a plot of land where you want to build a house 5 years after. So how will you protect it? What you do is you will lock your car, you will lock the vehicle, you may put a fence around the farm because you want to prevent trespassers or even cattle. And if you have a say plot of land where you want to build a house later on, you will put a boundary so that thieves don't enter, trespassers do not enter. You will lock your house and maybe for restricting thieves to enter into your house, you will use a burglar alarm, a CCTV camera, etc. But what you do if your property is intangible or not real, like a poem you wrote, a software you have prepared, a design of a machine or a plan of a model, say a design for a machine or a logo for your business, a play you have written, or a film that you have made. How will you prevent or how will you protect these properties? Do you have idea about these properties? These are all not your physical properties, but these belong to the intellectual properties, right? And how will you protect your intellectual properties? And here comes the role of IPR, or the intellectual property rights. Intellectual property rights are the rights given to a person over the creations of their minds. This is through your intellect, through your thought process, through your innovative minds, through your artistic ability, you have done with your own exclusive thoughts. So, as a creator, this exclusive right should be yours. And this creation enables you to get a exclusive right for a limited period of time, for a fixed period of time actually. And since IP can be stolen, made illegal use of, can be counterfeits can be made, we should prevent the faking of it, and later on reap the benefits of the hard work which had gone into the preparation and the creation. Now, IP protection is fast growing momentum as a way to reap the rewards later on for your novel creations, because by selling or by licensing IPs, you can gain profits later on. So it is fast growing as an industry for employment. But whenever we tell about IP, whenever we talk about IP, usually we talk about two things, right? We know about two things popularly, that is the patent and the design patent or the industrial designs. Patents are usually protected for invention, technology, processes, for something new, and the duration of the protecting period is 20 years from the date of filing. And for the industrial designs, for appearance, shape, or the design in 2D or 3D format, it is protected for 10 plus 5 years, that is 15 years from the date of filing. But are these the only two which we know of IP? Are these the only two things which we know, or are there other categories of IP? Do we know? Can you raise hand? Is there any other category of IP? So, see if these ring a bell. One of the most prestigious logo of, or the pride of a nation, the logo of Tata, the logo of Mercedes. Some of us may have a dream to own a car of Mercedes later on in our lives. This is the logo of Audi car. Those who are around 40, you may remember that the first Audi was brought to India when Ravi Shastri won the Benson and Hedges Cup and bought the Audi as a prize from Australia. And this is the golden arch of McDonald's. And whenever you see this logo, you will remember about the yummy McDonald's and other things. This is a catchy ringtone of, this is the sound logo. So, catchy ringtone of Airtel. These are of logos of Nike and Adidas. You may try or dream of owning a shoe of Nike, Adidas, and this is one of the most popular, most adored logo of the world of Apple, and this is the very own country logo of Zindagi Ke. This is not a logo, this is the slogan of Zindagi Ke Saath Bhi or Zindagi Ke Baad Bhi, that is the LIC, which also has a logo of a lamp surrounded by two hands. And this is our very own Amul girl, the utterly buttery delicious Amul girl. So whenever you see these logos, you instantly do a brand recognition and brand recall. And this is called the trademarks. This is another very important category of IPR. Almost immediately you remember or it rings in your mind about their products and about their services. These businesses are built around and have acquired immense reputation through their names, logos, and of course their products and services. Now, logos can be, or trademarks can be of various kinds, like word. Coca-Cola is always written in this format, and if it is written in other way, that is a counterfeit or a fake one. Logo of Apple and Toyota. This is a color logo. Color logo is Yellow Pages color logo, and in the Starbucks coffee logo is always green in color. It will never be blue or red. If it is, then that is not the Starbucks original. This is the sound logo. I will have to use this manually. So this is the Airtel logo, and if you remember, if you have seen Three Idiots, this sound logo was ringing in near the Pangong Lake, where Amir Khan was using this sound called ringtone, and this will make us nostalgic when we hear the Doordarshan logo, which we used to hear in our childhood, and many of you might be nostalgic hearing this. And this sheep logo. Toblerone chocolate is always the triangular shape. It will never be in a circular, cylindrical, flat, in any other shape. And Coca-Cola, they have also not only trademarked, they have also taken a design patent later on about the shape of the bottle. So the duration of the trademark is 10 years and it is extendable for 10 years. Properly, see, we call the Bengalis they don't have a business mind, right? Bengalis don't like business, but if you see this Dabur trademark, this is by some S.K. Burman, and the trademark was taken from Calcutta in 1944. So during and 1884 is during the time of Darokanath Thakur. You may be knowing that Darokanath Thakur was also a big businessman, though this is out of the topic. Still, I want to just say that Bengalis had a business mind at that period. Now, these two marks, all of you, I'm sure you have seen. But what is the difference between that TM and R? TM is an R. TM is when you have applied, you are using a trademark and you have you have applied it for registration, and your registration is still pending. But you can still use that trademark with the symbol TM. Without registration, it is still pending, not totally registered. And when it gets registered, you can use the logo R. That means your trademark has been fully registered. Is it okay? Now, criteria to protect a trademark are: it should be distinctive. It should not be similar to, or it should not be similar to any well-known trademark or of the same goods or services. It should not bear the emblem or official seal of UNO, WHO, Government of India, or any state government, or the Indian national flag. This is a mandatory criteria that it should not be used, and it should not bear the name of a chemical element or a compound or an ingredient of a drug or medicine. Foreign filing of trademarks it can be both ways. I mean, Indian filing of foreign trademarks or foreign filing of Indian trademark can be done. And you may submit a trademark application at once in several foreign countries together. We will come to this later on, might be in next lecture, tomorrow's lecture. Foreign filing through the Madrid system of WIPO. What is WIPO? Is the World Intellectual Property Organization. Through this process, you can do the patent filing in many foreign countries at a time. Well-known trademarks are those which has become so well known that if you try to fake it or imitate it, people will soon associate with it with the original trademark. Like say, if you want to sell your biryani, if you use Arsalan biryani, you can never use Arsalan biryani. You will have to use a new Arsalan biryani or the Arsalan biryani and Arsalan biryani of Howrah, Bardwan, like that, because you are trying to use the name of Arsalan, and people who are not so aware will think that this is original Arsalan biryani and will still buy few, and that is how the person who is doing the business is trying to fake or cheating. Trademark registry keeps a record of the trademarks of India, and you can submit trademark in one or more than 45 categories of goods and services. How I get my mark registered? So once you have decided on a logo or a name, first you have to do a checking or examination that it doesn't be similar with some other trademark which is already in existence. If it is so, then you have to make minor changes in those trademarks so that there will not be any future litigations. So next step is you first file the trademark in the trademark registry office, then you start using that TM, that is the trademark pending sign, and then the trademark registry office will do the examination and it will publish your trademark for 4 months. 4 months it will be in public domain, so that if anyone opposes the trademark, he or she has to do it within 4 months. If there is no opposition, then you can start, they will register your product and you can start using the R mark. If there is any problem, you have to do again minor changes and then again you have to submit it, resubmit it. So after this process, you can use your R trademark. Is trademark mandatory to start using my logo? No. You can start using a logo and carry on for 100 years without registering the trademark, but it is always good to use a trademark because it will give visibility, it will give name to your organization. So it is always advisable that you trademark your logo or name. You can submit your trademark application even after you have started using the mark. You can claim the date of use of your first date when you started using the logo as the registration date of the mark after the registration. I obtain my trademark, and what do I do now? You should use your trademark continuously, honestly, freely in all types of your websites, letterheads, office, communication, invoice, bills, chalans, etc. And you must see that it is protected. No counterfeit occurs. Similar trademarks they don't imitate you. And if there is such an occasion, you can always take a legal action against them. Make sure to renew your trademark after every 10 years. And the TM registry office, I told earlier, that it keeps the record of the trademarks of India. And trademarks can be renewed indefinitely, and it can be there for hundreds of years, for generations after generations. Trademarks can be random. More random it is, more protected it is, more less chance of litigation. Like Apple, a half-eaten apple for a computer company. Who will think of keeping the name Apple for a computer company, and who will think of keeping a name Subway for a restaurant chain? There will be least opposition when you use these types of names. The fun fact is that the oldest registered trademark in UK is the red triangle logo of Bass Brewery, which was registered in 1876. Just mark the word registered trademark, because later on we will have another contract. Trademarks are first come, first served, sir. I come up with a cleaning solution, say company, and I take my logo is a broom. Okay? And then next day you go with the same broom logo, and you want to do a company, start a company with the same logo. I will be given preference because I first took it for registration. So it is a first come, first served basis. People can also be trademarked. The Kardashian family has filed for the trademarks of the children's name. This is a fun fact. And trademarks do not expire, as I told you, it is perpetual. You go on renewing it generations after generation, and it will stay with you. Another Stella Artois is the oldest active trademark. This is not registered, but the active trademark, and it is a British brewery. Last one also I said British brewery, and this one is also British brewery. The British were very, they had their breweries in mind for so. The next category of IP, please see these videos. All of you know about Rasgulla. Many of you know of this Dokra art. This is the Nokshi Katha of Bengal, and this is the Vishnupuri Balachuri sari. And from here, what we go to the next, we jump to the next category of IP, which is the GI, or the geographical indications. So geographical indications originate in a particular place. Certain quality of reputation or reputation of goods can be attributed to the origin, class, quantity, soil, climatic condition, specific processing or preparation of techniques. Have you anyone heard about Beliatore matcha of Beliatore? So it has a specific processing technique. It is done in Beliatore only. GI is applied to agriculture or natural or manufactured goods. In case of manufactured goods, either the production or the processing or both is comes of a particular region is a very important factor for the GI tag. It carries enormous historical and cultural significance associated with the specific good associated with that place. Registration of GI enables an entire community of farmers, artisans, craftsmen benefits out of the GI status. This act came into being in 1999, and between 2004 and 2020, this is so important. After 1909, when this law was established, between only 16 years, 420 GIs were registered only in India. So some examples of GI in various categories of agricultural products is the Darjeeling tea of West Bengal, the Surkha guava of Uttar Pradesh, Kurk orange of Karnataka. Out of the natural goods is the Makrana marble of Rajasthan, Chunar Balua Pathar of Uttar Pradesh, the Mysore agarbatti, etc. Tangible paintings, Muga silk of Assam, and the Kashmiri Pashmina are very, very important. See, some GIs are so popular, and to increase their authenticity, they have also created logos for them. So not only the GIs, they didn't stop with getting the GI tag. They also have their own registered their own logo for authenticity. The Kutch embroidery, the Benarasi brocade, the Mysore agarbatti, the Odisha Potachitro. There is a village called Raghunathpur like this, and the Kullu shawl and the Bagh queens of Madhya Pradesh. A GI cannot be registered as a trademark. And if you want to know whether your local famous thing is a GI tag or not, you can check this website, and there are about trademark. I told there are 45 classes of goods and services, and GI there are 34 classes of goods which can be GI tagged. And this is the Royal Battle of Rasgulla. All of you know, and in the TV there was a great TRP war or the battle for Rasgulla. And the state of Orissa and state of West Bengal fought, they claimed the GI for Rasgulla, and who won? Both won, and for their own individual versions of Rasgulla. That is why now our Rasgulla, which is GI tag, is termed as Bangla Rasgulla, that is GI tag, and Odisha Rasgulla. See the difference of the spelling. Who can apply for a GI? It is usually the government, association of producers, authorities established under law. Usually the state government applies for the GI of a certain, would say Rasgulla, obviously West Bengal government, Vishnu Nagar Shortpuria Short Bhaja, West Bengal government, Kutch Embroidery, Gujarat government, or the federation, they will apply. And who is authorized? Usually those artisans, farmers, producers, they are the users of this GI tag. How does GI help you? This is very important. GI tag helps to sell your product as an authentic GI product, and this increases the globalization of your product as awareness for GI has increased many folds. Your product will be sold as a genuine GI product, and you may get a very good price for your product because it is authentic and original. GI tag also helps consumer to identify that this is the original product, and he will buy the original and authentic goods. It helps to protect the interest of farmers, producers, manufacturers, artisans, craftsmen, etc., and helps the local products to be recognized both nationally and internationally. Fun fact is that in the modern context, GI has become so important that only in West Bengal, 22 items have already obtained GI, and we have, West Bengal has given an application for GI tag of many other products. Just few importance are Darjeeling tea, mangoes, Lakshman Bhog, Heinz Chapor, Fojiliam of Malda, Govindabhog rice, Tulaibandi rice. These are very famous. And out of the handicraft are Nakshikatha, leather goods of Shantiniketan, Shantipuri, Kalchori, Dhania Thali, Shari, the Bankura terracotta, Bengal Dokra, Patochitra of Bengal, Purulia show mask and wooden mask of Pushpandi, and the Madhur Kati. And how does GI? Which are GI tag are the Joynagar Noa, Rasgulla, and the Mihidana and Sitabhog of Bardhaman. And West Bengal has also applied for GI tags for Vishnu Nagar Short Bhaja Shortpuria, Kalunonia rice of North Bengal, and Radhoni Pagod rice of the Rad district. And GI, so GI is also a very important category of trademark. And next, this is not so important, so I have it is done very briefly. The next category of IPR is the protection of plant varieties. Besides, India has gone into international agreement with other parts of the world for patent, design, trademarks, everything. But India has not, copyrights, but India has not entered into a treaty, international treaty for protection of plant varieties. Why? Because this could not be done, as the farmers would be, their freedom would be curtailed, and they would not have any freedom on the seeds, the seed variety. So they could not, India could not enter into the UPOP Act, that is the International Union for Protection of New Plant Varieties, which was enacted in 1991. And this would have seriously curtailed the freedom, future innovation and rights of our farmers. So India came up with its new own law for protection of farmers' variety as well as for the benefit of the farmers. India does not grant patents for plants. The Indian law encourages development of newer plant varieties and protects the rights of the breeders who want to breed new varieties of plant for the betterment of the mankind. Plant varieties can be protected up to 18 years for perennials, and for trees and vines it can be protected for 15 years. And international filing is also possible. One fact is, in country like India, agriculture is still the biggest industry. It is a way of living for the past generations after generations. And Indian farmers have devised several new innovative varieties of food grains, plant varieties, and they overcame the problem of drought, famine, floods, pests, etc. And they have given much more yield than the other previous variety. The IPR for plant variety protection is very important, and the following these are the varieties of rice plants or paddy plants which has been protected through Indian plant variety protection. Moti, Mogra, Lalgundi, we don't know all these because, but farmers do know it is well known for them. Shomudra Bali, Pustak and Rani Shahib are the various varieties of plants which are protected through this system. And that is all. This is the certification of IPR. And thank you so much for a patient hearing in this type of scientific condition. I thought I wouldn't finish, I would say only 15 minutes, but I rapidly went through it.